Lady. Perhaps if I can
Mr.
answer.
Rocker, we felt it was a bit hot in here this morning, and we have investigated without complete success for the purposes of getting it cooler. If at any point it gets insufferably hot, please make the appropriate application to remove jackets, and we'll look at it very sympathetically.
Grateful, my Lord. It's certainly much warmer in Gibraltar than it is here.
Well, lucky you.
I'm not so sure it's lucky, but it is what it is. My Lord, before I kick off again, perhaps I can quickly answer Ladyship's point on whether there's any impact on the English provisions. I've not been able to find anything that any ruling here would impact upon the English arrest warrant provisions. And I've looked at it, and my learned juniors looked at it over lunchtime.
There's no equivalent to Section 12 in the English provisions?
No. So nothing of concern in terms of any decision here impacting on...
One other question for you, and we only need an answer in outline. We're looking, I think, at a pre-Brexit day piece of legislation.
Correct.
Which I've no doubt has changed since Brexit.
Yes.
I have a vague recollection in the back of my mind that there may have been some special arrangement between Gibraltar and the rest of Europe. I don't know, but it would help us so that we can just think about whether there are any going forward implications in our decision. How much of this survives now?
My Lord, nothing now, because we're reliant on the 1959 Convention provisions. But for the United Kingdom, we still apply this provision here. So apart from the UK, there is no continuing
European Arrest Warrant in Gibraltar.
So
we are looking
only between Gibraltar and the UK.
Correct, and outside of that, we look at the 1959 Convention provisions.
Right.
It may well be that Brexit, and when we are negotiating, and we are in the process of negotiating our own specific provisions and treaty provisions, that something similar to a framework decision comes back in.
Yeah.
But as things currently stand today, no.
And so at the moment, this Act only applies as between Gibraltar and the UK.
Correct.
But then these sections do apply in that context.
To United Kingdom.
Thank you.
Well, I spent a little bit of lunch looking through Her Ladyship's ruling in the Supreme Court, trying to unravel it somewhat. And the best I can do is draw your attention to paragraph 20 at page 86 of the electronic bundle. It is clear at paragraph 20 and 21 that the process she undertakes is to look at the framework decision, which she does, and she recognises and identifies the difference in the wording of Article 5.3 as may, and the way that it has been transposed markedly differently into Gibraltar, she says, as must. And she says at the end of paragraph 20, although Section 8 is more absolute in nature than the corresponding provision of the Council Framework Decision, in my view, the interests of justice make it necessary to interpret Section 8.8 in a purposive way. So she does have regard to the framework. It's not that she's not considered the difference in the wording. Her Ladyship has, and has said that. And why does she get to that conclusion? Because she says, well, there's no doubt that Section 8A is aimed at protecting individuals who are nationals or residents in the executing state. And she says, but, that protection, in this case, becomes questionable. This is paragraph 21 of her judgment. When the residence has been obtained with the consequence of avoiding a term of imprisonment following a conviction in the issuing state. And later on she says, I constantly refer to the appellant as being a fugitive, and that's why she gets to where she gets in terms of a purposive construction.
The purposive construction is all very well, but you've got to find some words that it vaguely corresponds to, and here there isn't one. It says must.
My Lord, yes, but she's conscious of the difference in the wording.
Well, consciousness is one thing, but having some reasons is another.
My Lord, yes.
Do you not also have to take into account that under Section 33A, there is a discretion given to the courts in relation to serving sentence? In other words, you've got to make a judgment as to whether or not you're going to have them in Gibraltar, whereas the statute clearly didn't intend that to be the case here.
It's a slightly different provision, Section 33A, to do with transfer of prisoners and serving sentences. But yes, you require a court order, conscious, but there's also a discretionary provision there in refusing that that application also.
But discretion was put into the statute in 33A and was removed in this provision.
Yes, and in fact you'll see, my Lord, that in all the provisions that are non-mandatory, Gibraltar just blanket made them mandatory, effectively, used mandatory language. It just block said, well, everything. I don't know whether that was an intentional decision or simply the simplest way to legislate. Our Hansard has been of no use in that regard. If I can turn briefly to the framework decision, which my learned friend has already referred you to at page 303 of the bundle. And there are a couple of recitals I wish to refer the court to. The first one is at bracket 5, and the object of the union. And at the end of paragraph 5, it's to remove the complexity and potential for delay inherent in the present extradition procedures. That was the idea of the framework decision, to stop procedural issues, to speed things up, to make things and cooperation between member states far more functional and proper. It's the cornerstone, if you look at paragraph 6, of judicial cooperation. And you'll see in a number of authorities, the statements always...
Well, it would speed things up a lot if there's no discretion to exercise. It's just must, and you get it, and off you go.
My Lord, yes, but of course...
Instead, we end up here. Not a very speedy process.
Well, my Lord, that's right. But if you look at all the authorities, what the authorities say, the usual rule is you execute the warrant. It's the exception rather than the rule because of the cooperation between the European Union and the member states. And, yes, we've got this social integration provision, but also that needs to be, and I'll refer to your lordships to the case of SF, how that also sits parallel with the requirement to have people and fugitives do time for their crime. They must be punished, they must be returned to the member states, and they must be punished for what they do. So the social integration provisions don't sit alone, they sit in parallel with everything else. And I think, although not said by the learned judge, that is really what she's kind of trying to say is, well, social integration is important, but A, you're not socially integrating into Gibraltar, you're from Croatia, your family is there, your property is there, you have no family here, you should be back in Gibraltar. And secondly, I'm not allowing you to circumvent the rules by becoming a resident, a fugitive resident, and avoiding being returned to Croatia because of this interpretation that you're insisting on.
It doesn't avoid return, then. It just allows you to serve any sentence in Gibraltar. With
an order of the court. The section 33 provision is slightly different to the section 8.
In that case, yes.
8.3. I don't need to deal, I'm grateful to a friend, with Assange. So I can skip through those provisions. And apologies for the late submission of Cretu, but I just thought it was appropriate to file it in court this morning. My learned friend has already addressed you on proceedings concerning IB, which I don't need to tax you with. So I'm going to move on briefly to the proceedings concerning X, which I think are of some, I submit, of relevance, analogous relevance.
Could you just remind me where Article 4 is enacted in the domestic legislation?
Arrest Warrant Act.
I think it may be section 34.
the reality is that those provisions, Article 4, are all over the place. Yes, Section 34 is one of them.
Yeah.
Section 33 is another.
No, I'm just wondering what wording there is in the 2004 Act to implement something which does require, which more clearly does require a discretion to be conferred on the judicial authority, according to IB.
If your ladyship looks at page 234, 235, 236 of the bundle, there are 33A exceptions due to surrender, execution of sentence, section 34(1), exception due to surrender, trial in absentia, and over the page 34A, withdrawal of European Arrest Warrant, not necessarily relevant, immunity and waiver, 35(1). But as you'll see, my lady, all the optional provisions were phrased in such a way as to make them mandatory effectively. And I know your lordships may think it's a distinction without a distinction, but the guarantee provision is a condition precedent provision separate to Article 4 and Article 3 provisions on mandatory and non-mandatory execution. I slightly distinguish the return certificate provision. It's not that it's in Article 3 or Article 4, it's separate and apart from. And I accept that in many ways that causes me slightly different problems, but I think it's important to point that out. My lords, if I could take you to page 511 of the bundle. And conscious of the difference in wording of Article 4 and the Member States' duties and obligations here, what X essentially does is makes a optional non-execution provision. The Dutch transpose that into a mandatory provision. And that's at page 514 of the bundle. So the option was made mandatory by the member state in a similar way that the Article 8 certificate has been made mandatory in Gibraltar. And if I can take you to page 517, paragraph 30, bracket 1, the questions to the Court of Justice for a preliminary ruling were, should Article 4.5 of the framework decision, i.e. the optional ground, be interpreted as meaning that where a member state chooses to transpose that provision to domestic law, mandatorily in this case, the executing judicial authority must have a certain discretion as to whether or not it is appropriate to refuse to execute the European Arrest Warrant. And over the page at 518, and paragraph 37 onwards, the question is effectively answered. Paragraph 44, page 519, and 43, it is therefore clear from the wording of Article 4 of the framework decision, in particular from the use of the verb may, together with the infinitive of the verb refuse, the subject of which is the executing judicial authority, that that authority must itself have a margin of discretion as to whether or not it is appropriate to refuse to execute the European Arrest Warrant on the grounds referred to in Article 4. And then paragraph 44, it follows that when they do opt to transpose one or more of the grounds for optional non-execution provided for in Article 4 of the framework decision, member states cannot provide that the judicial authorities are required to refuse to execute a European arrest warrant formally falling in the scope of those grounds, without those authorities having the opportunity to take into account the circumstances of each specific case. The interpretation of Article 4 of the framework decision is borne out by the context in which the article arises. First, as the Court has repeatedly held, execution of the European Arrest Warrant constitutes a rule, whereas refusal to execute is to be an exception which must be interpreted strictly. And it refers to SF. As the Advocate General noted in point 44 of his opinion, a national provision which would make it impossible for the executive judicial authority to take into account any circumstance specific to the individual case which might lead it to consider that the conditions for refusing surrender have not been satisfied fundamentally would have the effect of substituting a mere option, provided for in Article 4 of the framework decision, with a genuine obligation, thus transforming the refusal to surrender from the exception into a general rule. And my argument, my Lords, is that by analogy, that gives the judicial authority in Gibraltar a margin of discretion when looking at Article 83A, the circumstances of the particular case, which is what the learned judge does in this case. Paragraph 60, it follows that the specific application of the ground for non-execution provided for in Article 4.5 of the framework decision must be left to the discretion of the executing judicial authority. And I remind your Lordships that it was a mandatory language that the Dutch authorities transposed that article into, which to that end must have a margin of discretion allowing it to carry out an examination on a case-by-case basis, taking into consideration all of the relevant circumstances, and in particular, the circumstance in which the requested person was tried in the third state in order to determine whether the failure to surrender that person would be such as to undermine the legitimate interest of all the member states in preventing crime within the area of freedom, security and justice. And that is the point that I'm clinging to in X. And this feeds back into the Pupino principle and the common law statutory interpretation principle that we need to give this the highest possible margin of interpretation because we are seeking to comply with our international obligations. And to limit the scope of that international obligation in the manner in which legislation purports to do doesn't flow effectively from the purpose and the objectives of the Framework Directive. And that's what the trial judge does, the Supreme Court judge does. My Lords, if I could, my Lady, if I could briefly refer you also to the proceedings concerning SF, that's at 761 of the bundle. This case is also of some use and relevance, my Lords. It's relating to the Dutch authorities requesting the Home Office to guarantee that requested person's surrender will be subject to conditions set out in Article 5.3 of the Council Framework Decision, i.e. that it will be returned to the Netherlands in order to serve there any sentence or detention order passed against him in the United Kingdom. And if I can take the Lordships to, the Ladyship to paragraph 59, the opinion of the Advocate General.
But just before we move on, just reflecting on X, the point in X was that the way the Dutch law interpreted it was a blanket refusal to execute the warrant in circumstances, and that wasn't permitted.
That's right.
But we're not talking here on any view about a blanket refusal to execute a warrant. We're just talking about whether it's going to have a condition attached about where the person serves their sentence.
If we read it as a must, my Lord, then it would be a blanket prohibition without the warrant. And what the margin of discretion does is, with respect, say to the trial judge, yes, on the whole it's a blanket mandatory no, but you look at the circumstances of the case, which is what the trial judge does, and says, well, I'm not allowing you to take advantage of the structure of the European Union and these procedural rules to avoid being returned to your country where you should be serving your time. That's effectively what she does. And you're right, X isn't precisely on point, but by analogy, I think that it's open to a trial judge to exercise that margin of discretion when looking at the may-must provision in this case, because it's similar to what happens in X. It's a must transposed into it's a may transposed into a must in the Netherlands. The Article 4.5 optional provision is transposed into a must, which is similar to what we have here. The may return certificate is transposed into a must return certificate. But by analogy, the process must be the same, which is to allow the judge a margin of discretion to look at each individual case and say, well, in this case, I'm sorry, but this must is a may, and that's what she does. And I put it no higher than that, my lord.
Sorry, I took you away from
No, my lord. Delighted to answer any questions. If I can, page 774 of the bundle. And this is the Advocate General's opinion. And I merely flag up paragraphs 58, 59, 60 and 61 for your lordships. What effectively it says there is, even though the main objective, Article 5.3, is social integration, that's got to be reconciled with the objective of a complete and effective punishment. So the framework decision also pursues the overriding objective, and the words of combating impunity. So there's a balancing. Social integration with combating impunity of criminals, avoiding these provisions. Because it comes back to the overriding principle, which is non-compliance with a warrant is the exception rather than the rule. But I'm not going to labour the point about...
Did the court follow that precisely?
No, it doesn't say it in precise words, no, it doesn't.
The court's approach seems to be rather more restrained.
It does, yeah. And I hunted through it to see whether I could find, but it doesn't do that. It's simply the Advocate General's opinion. Yeah. But all he simply does is highlights the different, if I can call them pillars, of the European Arrest Warrant provisions. So even though 5.3 is a social integration article, that has to be balanced with punishment, and not allowing people to avoid punishment with impunity and escaping the laws of the country in which they are effectively.
And there's no criticism in here of this being a blanket refusal?
No. My lords, I don't propose to take long on Peppino. I think that it's a well-known for everybody. And what Peppino effectively requires, paraphrasing, is, as far as possible, in light of the wording and purpose of a framework decision, that the courts interpret national law in accordance with that to obtain the objectives it pursues, which is why I've referred to X. It's why I've referred to the cornerstone of judicial cooperation. It's why I've referred to not having people, fugitives, act with impunity and escape the measures that are imposed upon them. And that's what Peppino requires us to do. So, in my view, if we were to apply the interpretation of conformity principle, we would look at the framework directive, we would balance all those things out, and her ladyship, albeit for different reasons, should and could have reached the same conclusions. And there's little difference between the Peppino principle and the domestic rule of statutory interpretation. I think Assange recognises that Parliament legislates to give effect to an international obligation. It's presumed to do so in full. And there is a paragraph 6.3 of our skeletons reference to Cando Amas, where he said, paragraph At page 437, Lord Bingham, paragraph 8, said, the interpretation of the Extradition Act 2003 must be approached on the twin assumptions that Parliament did not intend the provisions of Part 1 of the Act to be inconsistent with the framework decision. While Parliament might probably provide for a greater measure of cooperation with the United Kingdom than the decision required, it did not intend to provide for less. And arguably, if we interpret this provision as mandatory, we are providing for less. And I accept, of course, there's plenty of data that says that it's always subject to the will of Parliament, and I do acknowledge that. Just as a side note, it's interesting to note that actually when the Act was initially enacted, it didn't contain any provisions in relation to guarantees, and it underwent parliamentary scrutiny. And that was later added by the 2014 regulations. I don't see any terms on it. And I seek to make some argument about confusion of Parliament and the mischief in my skeleton arguments, but I accept it's not my strongest point, and I won't labour it. It's at paragraphs 6.7 to 6.10 of my arguments, but I don't propose to take your Lordship's ladyship through that. I don't think it's a strong point.
So you accept that the inserted provisions are to be interpreted in the same way as the provisions that were originally in the Act?
There's nothing to suggest the contrary, lady, yes. I mean, the point I was making is because it was done by regulation, it didn't undergo parliamentary scrutiny and debate.
I think that was a point that the judge relied on as well.
That's right. I mean, even when grammatical meaning of words are clear, my lords, my lady, the court might need to give, on occasions, a strange construction to legislation to achieve the legislative purpose. And I don't propose to take you through it, but there are various extracts from Benyon in the electronic bundle. And the purpose of the Act, to give effect to the Framework Directive, was to provide a simpler, refined system of surrender to ensure that crime doesn't go unpunished, and that a person serves his custodial sentence, and it must be weighted against the wording of that provision. Again, refusal to execute must be exception and not the rule. My lords, my lady, in his affidavit, which is at bundle 70 to 72, the appellant states he established life for himself in November 2015. The date is disputed. By working and forming a relationship and friendships. But on the other hand, it can be gleaned from the letter of the 11th of March, which is at page 50 of the electronic bundle. He was born in Croatia. He lived there until he was 39, 2015. He owns lands there. He is a co-owner of a flat and has a son there, aged 14.
But are you saying that he's not then resident in Gibraltar?
Technically, he is resident. He had a residence. But
are you saying that the court, in deciding whether to exercise the discretion that you say is there as to whether to require the undertaking to comply with the return condition, should investigate the strength of the link that the person has with both countries? What
I'm saying, my lady, is that the objective of Article 5.3 is social integration. And clearly, her ladyship, in her judgment, didn't believe for one second that Mr. Katic, even though technically a resident, was integrating into Gibraltar society. Everything pointed to the fact that his social integration was in Croatia.
But surely the judge said that she'd have made the same decision, ignoring all the material in the letter.
She also did say that, my lord, yes.
But I mean, she had no material there for her to sustain any of that, did she?
She had the affidavits before her, yeah. And she had the letter from the respondent.
But she left the letter out of account, she said.
Yeah, she doesn't mention it.
No, she says, even although I got the letter, I didn't take it into account.
That's right, because she simply considers him a fugitive running away, and
yep.
And playing the system. That's effectively what he's doing. He's forum shopping, is what she thinks. And I'm not letting him do that. And what she effectively does is she just says, you know, it's inherent injustice that a fugitive that all of a sudden becomes a resident. He's not a bona fide resident, although he is a resident. He placed himself outside the reach of the Croatian authorities. And on that ground, she says, well, you know, I'm perfectly at liberty looking at a purposive construction of must and may, and looking at the framework decision, and looking at our obligation to interpret our laws in accordance with international obligations, and Pupina, although she doesn't mention it, to come to this conclusion. It's her margin of discretion. I can look at the circumstances of the case. And even
That's
though
fine if we've got a discretion, but we ought to be focusing on Article 5, oughtn't we, and seeing whether you can get out of that the requirement to have a discretion. Can we have a look at that?
Article 5.3, Mark?
Well, 5 and yes, 5.3, but the preamble. So I'm just following up what Lord Briggs was saying this morning. There is a reference to the executing judicial authority in Article 5. Perhaps one can say that your argument is it that when it says the execution of the warrant by the executing judicial authority may, by the law of the executing member state, be subject to the following conditions, that is, the law of the member state might not choose to allow that to be done. But if it does, then that's, you say it's the judicial authority that has to then make the decision whether to impose such a condition or not.
Precisely.
And there's another may in the 3, isn't there?
There is another way, another may.
So arguably, although the law, it doesn't say the law of the member state may decide to confer a discretion, but you're saying, well, if they could choose, it's giving them the option, but what they can't do is say that such a condition must be imposed in every case by the judicial authority.
You can't bind the judicial authority because that's not what's believed by the framework decision, because you are constraining the margin of discretion of the judicial authorities to look at the circumstances of a particular case and to interpret the law in accordance with those circumstances, which in this case, I think the grounds were quite strong, interpreting it in the manner she did.
I mean, if you look at Article 4.1, which is, I think, part of what was covered by IB, this is at page 307.
Yes.
The executing judicial authority may refuse to execute the European Arrest Warrant if the act on which the warrant is based does not constitute an offence under the law of the executing member state. And then if you look at page 227, which is how that's been implemented, which page 227, section 27.1, a person shall not be surrendered to an issuing state in respect of an offence unless the offence corresponds to an offence under the law of Gibraltar. So now I could see that you could say, on the basis of IB, well, that is not a conforming interpretation because that appears to ban the judicial authority from or doesn't give the judicial authority any discretion as to whether, even if there is no corresponding offence, they still want to execute the warrant. And what you're saying is that just as one would have to read down now 27 and maybe 28 and 29, various other provisions that purport to implement Article 4, but not to confer a discretion. So the same is with the provisions that we've been looking at.
On one argument, yes, you would read them down. The distinction I drew at the beginning, my lady, was that the Article 3, Article 4, Article 5 provisions are slightly different, because Article 5 is effectively a condition precedent provision rather than a mandatory or non-mandatory ground for executing a European arrest warrant. That is a slight subtle distinction between the Article 5 provision and Articles 3 and 4. And Article 4,
I thought you want to emphasise the similarities, and it does seem a bit extraordinary that you have a discretion where the person you're just considering sentence, but no judicial discretion potentially, where you've got the same question, but you're talking about sentence following a trial.
I'm actually in agreement. I'm saying Article 5 is even weaker, because I would read down sections 27. I would read those down in the same way as Article 5.3, but Article 5.3, the argument, I believe, is even stronger because it's a condition precedent provision rather than a mandatory or non-mandatory Article 3 or Article 4 provision. So the argument is even stronger, in my view, for Article 5 for reading it as a may than Articles 3 and 4, and the corresponding provisions in the European Arrest Warrant.
And would you also read down 8A2?
Well, the European Arrest Warrant, the framework decision, framework directive, actually makes that a must also. That's not a, I believe that's a must as well, in the same way that the ultra-fire quick provision is a must. From recollection, I'll check.
No, it's not.
Just look at 2.
Check.
It's the same wording as 3.
Yeah.
I'm trying to find it in the framework decision, my Lord. Sorry.
Sorry, it's 5.2.
5.2. Great.
Page 309.
Yes, that must also be read in the same light as a may.
You need to be very careful about your domestic law, I would have thought, Mr. Rockham.
Well, all it does is allows the judge to look at the circumstance of a particular case. That's what it does. It doesn't make a may a must or a must a may. It simply allows that judge that margin of discretion to not have what in this case she saw as an abuse of the system and the powers that are available by Mr. Katic. And she wasn't allowing it in the interest of justice. And that's why she gives it that purposive consideration. I mean, it may well be in relation to Article 5.2 that the arguments of discretion, margins of discretion are slightly different, because it seems to be a relatively straightforward provision in terms of the penalty of 20 years. So I couldn't see that being read down, even though potentially I could see that it could be read down.
Yeah.
Well, we submit that regardless of the approach and whichever of the angles one comes at this at, be it Pupino, common law statutory interpretation, margin of discretion, we say the result is ultimately the same one, because it gives that judge that possibility of reading our domestic provisions in light of the framework decision and interpreting it in light with those international obligations. And essentially, whichever argument we deploy, we could come to the same conclusion in terms of it's in the interest of justice. And I appreciate the interest of justice term as a very vague and notional term, but we get to the same outcome. My Lords, my Lady, I don't propose to take you through any more of the provisions or any more of the case law. Pauliska is there. It's referred to extensively in Her Ladyship's judgment and how she gets there. And we would submit that for the reasons, when you look at the framework decision, when you look at X by analogy, when you look at Popina, when you look at the common law duty of interpretation, the outcome is that the judge should be entitled to look at this provision and say, well, this is what the framework decision envisaged. Parliament has done this, but as X points out, it does not constrain me from looking and having a margin of discretion to analyse each individual case to determine whether I should return them, because returning them is the rule rather than the exception. And we should not dumb down our international obligations by making this, in wording at least, mandatory rather than non-mandatory. I don't know if I can help your Lordships and Ladyship any further.
I wonder, could I just clarify the point about the what happens if you get the subsequent guarantee or coming in, and just go through the statute to understand how that happens. So you have the in 8A3 you have the provisions which have to be in place before it can be transmitted, right? And then you come to section 12 of the Act, which deals with the actual surrender. And I think that it can be found, and going to the precise.
Go to them.
Yeah. Yeah. So where a person doesn't consent, the issuing state may, after hearing the person, make an order. Subsection 1 applies subject to the European Arrest Warrant is transmitted in accordance with Section 8 and where appropriate the undertaking, so that here there is, if you like, a distinct legislative architecture in relation to these 8A undertakings. Is that right?
Lord, yes.
And the distinct architecture requires that those matters are provided for at the initial hearing at the Magistrates Court, and that the appeal provisions make it clear thereafter that the limitation on appeal, as it were, means that it's too late at that stage for the provision of the guarantee to change the position.
My Lord, yes, unless, and my learned friend I think conceded this point, there's a possibility that you could make the order subject to receipt of the guarantee.
I just wondered about that, given what the statute actually says. It doesn't.
My view is it's on the order. That's my primary view, is that on granting the order, the guarantee should be in place, and that if it's not, you're pretty much trying to walk up.
Really, if it's not there, what you're saying is that the magistrate should wait until they get it.
The magistrate has the power, as my learned friend has already pointed out,
to
request further information before he makes a decision.
But your case is, but he also has a discretion to dispense with the need to have the guarantee given.
Yeah.
Yes.
That's your fundamental case. Yes.
Yeah.
And you can rely on the words "where appropriate" in 12(2)A.
Yes.
My Lord, yes.
Can I just ask, is your case entirely on conforming interpretation? In other words, do you accept that if one was just reading Section 8A in conjunction with Section 12, it would be mandatory, but one must read that down in order to conform with Article 5 as interpreted by analogy with proceedings in relation to X? Or is that your fallback position, and your first position is actually on the wording of Section 8A and Section 12? There is a discretion even in the domestic legislation, maybe from where appropriate or from some other.
My lady, that would be my fallback position. So my first position is with the conforming interpretation provision, that we need to read this as a must, as compared with X. But
usually you don't do it that way round. Yeah. Usually you interpret the legislation, and then if you think it means something, you decide what it means, and then you look at whether that's in conformity with the EU provisions.
Yes, which is why I said at the beginning, all four aspects, there's four aspects to this interpretive process. There is the Gibraltar interpretative provisions in Benyon, which we are allowed to give certain legislation, we look at the mischief, we look at the purpose of the legislation, and that's what the trial judge does to a very large extent. She looks at the purpose and she says, I've looked at the framework decision, and I'm reading this as a mate. She actually doesn't, my ladyship, she doesn't mention propina at all. She's not addressed on the conformity principle or on the common law statutory interpretive principle of complying with international obligations. She simply does it on the basis of, I've got the power here under consideration of the mischief and the purpose to look at this legislation and rule it's a may rather than a must. That's what she does. My argument is, whichever way we come at it, whether we come at it from Justice Prescott's argument or whether we come at it from the Pupino argument or the common law statutory interpretation of international law provisions, or we just look at the European framework decision, it comes to the same position, which is the judge is perfectly entitled to read this in context and come with a may rather than a must. Whichever way we get there, my lady.
Was Section 33A put in at the same time as 8A?
Yes, it was.
And one of your arguments is simply that it wouldn't make sense if one was a discretion and the other wasn't. It's just there's no rational. My learned friend, when asked by Sir Declan Morgan whether there was a policy reason for having a difference, he couldn't offer one.
No, and I can't either, because as I said, this was amended by Regulation 2014, so there really was no parliamentary debate. It was passed without any consideration of policy that I'm aware of, although my learned friend could be aware of. But I take your point on 33A. I shall remain on my feet as I can see my lordships are all manageable thinking. Or
no, thank you very much indeed.
I'm grateful.
Yes, Mr. Azapadi.
My Lord, can I just start at the end of my note when I was taking notes of what my learned friend was saying? Can I just start here before I forget what's in my head, which is and his response to the invitation of my Lord Legate that why is it the strange, apparently strange, position between Section 33 discretion and Section 8A no discretion. What I would say to that is that perhaps the answer is in taking a step back and first of all seeing firstly that the source for those provisions lies in two different source articles. So Section 33A, the source of it is Article 4.6, which gives a discretion to the judicial authorities. Secondly, that the source for Section 8A3 is actually Article 5.3. Which, for the reasons I outlined this morning, isn't prefaced by the same words as Article 4, and rather is prefaced by words that imply that the discretion is for the state to amend its law one way or the other. Thirdly, I'd make this point that, on the face of it, Articles 4 and 5.3 are Article 4.6 is wider than Article 5.3. So Article 4.6 applies also to people who are staying in a particular country. Those words, staying in, are not in Article 5.3. But probably, I would say, and here I am bravely putting it forward, that it might be that part of the reason is because of where the framework decision came from and where it has evolved to. Because, of course, in 2002, when this framework was devised, Article 5.3 talks about a warrant which is for the purposes of prosecution. Article 4.6 is about the service of a custodial sentence in a particular country. It was not until the case of IB in 2011 that the phrase for the purposes of prosecution was also interpreted to mean to apply to cases where someone might be sought for the purposes of serving a custodial sentence, but he may have been tried in absentia, the case of Katic, for example. So it's only in 2011 that the phrase evolves to have a wider ambit, and it may be that then, yes, if you have statutory provisions in your legislation, in some cases there is no overlap whatsoever. So, for example, if there's a person who is staying who is not a resident and not a national, well, that person can only fall under Section 33A, and there would be a discretion for the court to decide yes or no whether to grant that order. That person would not be entitled to an 8A3 mandatory condition. But there may be some cases now, yes, where there is a requirement for a mandatory condition, where the court can decide, for example, that in its discretion, it is, if the court were to face this kind of situation, the court could reject a Section 33A application in its discretion, but then be required, in some cases, to insert a mandatory condition because of Section 8A3. That is correct. So I accept that. But the source of those provisions are quite different, and we would submit quite strongly that the submissions being made by my learned friend offend the principle of conforming interpretation to the extent that the submission being put forward, in effect, is advancing a proposition that would be contra legem, as is.
Okay, can we just look again at Article 5, because that's the crux of this, isn't it?
Yes, my lord.
And there is a double may there, so to speak, isn't there? There's a may in the preamble by the law, and then there's a may be subject.
Yeah.
Isn't at least one way of reading it as saying that the law of the member state has a discretion, if you like, whether to confer a discretion on the judge. And so it may decide not to give the judge any such discretion to require such a condition, or it may decide to do so. But what it doesn't do is to allow the law of the member state to give the judge judicial authority no discretion and to say that it must be subject to a condition.
My lord, it would. I think the problem with that view, which is advanced, of course, by my learned friend, is that you've got to construe the may be subject to the condition. The similar phrase, you've got to construe it differently.
Why?
Because the first one, the may by the law of the executing member state be subject to the following condition, that's clearly a discretion on the member state to amend its law one way or the other.
So you're saying that the inherent in the concept of something being subject to a condition is that it is
a condition.
mandatory, that the words subject to a condition are not words which indicate that there has to be a discretion conferred. Because if you've got a discretion to do something, then, or you've got a discretion to allow something to happen, then that's different from saying that in order for that to happen, it's subject to the condition that something else happens, is that?
Yes, my lady, in essence, either there's a condition or there isn't a condition.
Well, it may be that if one looks at the words "is returned" and replaced them with "may be returned," that one would have then introduced the relevant discretion. In other words, as you say, the condition is what it is, but if the condition was "may be returned," then that obviously would introduce a measure of discretion for the court, it seems.
I think if the condition's imposed, it has to be a mandatory condition on the receiving state, but the question is whether the judicial authority is can be obliged by the law of its own member state to impose such a condition, or whether the most that can be done is to give it a discretion to make the return subject to such a condition.
Yes, and our submission is that in accordance with the principles that govern the interpretational exercise, that we've got to take the statute as it's set, as it's on its face, and that the intention is clear, and there is nothing in the mandatory nature of it that offends the interpretational exercise. And indeed, what I was going to do as well is take your lordships very briefly to the case of Satkovsky, which is it is as I understand, it's an electronic bundle 836. It's an extradition case in the divisional courts post the opt back in. What we would respectfully put forward is at 842, when the court considers the concept of conforming interpretation, they rely on the summary of the Court of Appeal in Vodafone and Revenue and Customs Commissioners. And they say this, quoting from that case at the top of electronic bundle 843, the only constraints on the broad and far-reaching mature of the interpretive obligation are that the meaning should go with the grain of the legislation and be compatible with the underlying thrust of the legislation being construed. An interpretation should not be adopted which is inconsistent with a fundamental or cardinal feature of the legislation, since this would cross the boundary between interpretation and amendment, and B, the exercise of the interpretive obligation cannot require the courts to make decisions for which they are not equipped, or give rise to important practical repercussions which the court is not equipped to evaluate. And one of your lordships asked my learned friend this morning, is there a decision where it has been held that Article 5.3 imposes a discretion? And I think the answer of my learned friend was he could not find an authority. Well, certainly we can't find one either in that sense. And my Lord Morgan referred to the case of Poplovsky, I believe this morning, just before the break. And as his lordship will know, that first of all, that case is of course it's an Article 4.6. 4.6 case. Yeah. It's a 4.6 case, and it's again one of those Dutch cases where the court had said in Holland that a Dutch person, as I understand the case, a Dutch person could not be surrendered at all. It could not be surrendered for the purposes of execution of a custodial sentence under 4.6. It could not be. Well, that's first of all, it's an Article 4.6 case. Secondly, that is about removing the obvious discretion in Article 4.6, the opening words of Article 4.6, which clearly impose a discretion on the judicial authority to take that decision. That's what the Dutch law was saying, and the court held that of course there has to be a construction of national law in light of the objective of the framework. Well, here the framework objective we would say is clear. At best, the construction being advanced by the other side is extremely strained in its scope, and we would say the choice of the form and methods, as it's up to the state, there is nothing to really suggest that the conflict, being advanced by Croatia, is in fact a real conflict. When you apply when you look at the Article 5.3 and when you look at Section 8A.3, we say it's plain on its face, and the exercise that we need to follow, which is one of conforming interpretation, the state has entirely adhered to that by imposing a mandatory restriction. My Lord, if you bear with me a second, because I've started from the back forwards, this always is a bit of a trial. Just a few points, if I may. I've dealt with the difference between 33A and 8A, so I don't accept the point. I heard my learned friends suggest, in response to my lady's question as to whether Section 33A was mandatory, I heard him. I understood him to say that it was mandatory. I don't accept that. I don't believe Section 33A is mandatory. It's clear on its face. I say that Section 33A is about the court having a discretion at the end of that process. It's clear from the last subsection that that is so. In any event, it's not, of course, the process we're involved in. My learned friend again advances the case of X. All I'd say about X is what I said this morning. X is irrelevant as far as we say, and to the extent of the relevance of X, the relevant paragraph in X, I would say, is paragraph 63 of the judgment, where it's repeated. Same point in Pupino is repeated, that the principle of conforming interpretation cannot serve as a basis for an interpretation contra legem, which is really where we say we are. And
so what would be the position with regard to those other provisions of the 2004 Act, which do seem to conflict with
yes.
X, because they are purporting to implement discretionary matters from Article 4, but they appear to prevent the judicial authority from executing the warrant if one of those situations pertains.
So, as your ladyship knows, Article 4 has 7 sub-articles. Article 4.6 is reflected in 33A and is a discretion. To the extent that some of the other 6 sub-articles are reflected in other sections of the Act and remove that discretion, if this was that type of a case, well then, what I would say is my learned friend would be on strong ground to say that those sections could not be read that way. In the context of conforming interpretation, you'd have to read those sections to conform with the objective of Article 4. But this is not that type of case. This is an Article 5.3 case. This is a different case, and we're not there. And therefore, that point does not hold good insofar as Article 5.3 or Section 8A, which is the reflection of it. And there is no authorities to support my learned friend's proposition as he advances it. My lords, my lady, I don't really have much more, but happy to answer any questions that your lordships, my lady, may have.
You agree with what Mr. Rocker said about the implications for the future of the interpretation of this provision post-Brexit?
Oh, so my lady, thank you, because actually I had it on my list, but because I started back to front, I did thank you for the opportunity. So my learned friend is right that this Act at the moment does not apply to anybody else other than the UK. So I was going to give you this reference, if I may. So I wanted to give you this reference so that the board had it in case it is of any relevance to the background. So at electronic bundle 190, 190, what you will see is, I'm not going to disagree with my learned friend, I agree with him, but I'm just giving you the source of what his submission was. So at 190, you will see that state means a member state of the European communities other than the United Kingdom and the United Kingdom. Under the 2020 regulations, it now reads, state is now a state designated by order for the purposes of this Act by the government or the UK. No state has been designated. Now, the source for that, I'll just give you the reference, that comes from the 2020 regulations, and that's electronic bundle 612. So no state has been designated. My learned friend is right. We are, in Gibraltar, we are still in the midst of negotiations as to a possible future treaty, and it may be, depending on the outcome of that, that the government decides to extend it. But at the moment, this is only an act that applies as between the United Kingdom and...
But the current contemplation is, because of that formula, that this structure could just be applied by designation order.
Yes.
So as to have a wider impact than it does have today.
Yes,
yep.
Correct. It may be that in future it's not used, it may be in future that it is used, and it may be that the government is simply awaiting the outcome of those negotiations.
Thank you.
My Lord, then finally, can I just say, because also on my note on the same page, that I was going to say that just simply before lunch, my learned friend talked about the powers of the Supreme Court, and we repeat the submissions we made this morning that we consider the powers of the Supreme Court were quite limited.
Yeah.
In the absence of a cross appeal, or of course, which there hasn't not been, then the powers are very limited.
If you've got what you wanted, it's quite hard to know what you could cross appeal about.
Yes, true. True, my lord. True. Very true. Thank you. Those are my submissions.
Thank you very much indeed. Well, we're most grateful to Council for their industry and the clarity of their well-researched submissions, and with the patience and care with which they've answered the battery of questions which we've fired at you, and grateful to those who invisibly have contributed to that presentation. The board will take time to consider what advice we'll humbly tender to Her Majesty.